Welcome to Beyond Borders, the Immigration Evaluation Podcast. I'm your host, Dr. Mariella Shibley, and this is where we simplify the process of immigration evaluations into clear, actionable steps. If you're a psychologist, therapist, or social worker wanting to add this life-changing service to your practice, hit that follow button and let's jump in. Today, we're diving into a very recent and important change that affects those of us who conduct immigration evaluations. More specifically, those working with Form N-648, the Medical Certification for Disability Exceptions. So this is an extra episode that I decided to sneak in because the update just went into effect on June 13th, and I want to make sure that you're all up to date and well prepared. So in this episode, we're going to unpack what these new changes to USCIS policy mean for us and for the naturalization process overall. So if you offer the service to clients who need a disability exception, then this is an episode that you don't want to miss. So let's dive in. As of June 13th, 2025, USCIS has implemented new policy changes that affect how this form is submitted, processed, and evaluated. These changes are designed to prevent fraud and to increase the integrity of the naturalization process. But they also introduce a host of new requirements, such as tighter scrutiny and greater responsibility for us as mental health professionals. So let's begin by grounding ourselves in what the N-648 is all about. When a person applies for U.S. citizenship, they typically need to demonstrate proficiency in the English language and knowledge of U.S. history and government, or civics. And that's what we often call the civics requirement. Now, back in 1994, Congress recognized that some people with disabilities or impairments might never be able to meet those requirements, even with reasonable accommodations. So they created a legal exception for individuals whose medically determinable physical or developmental disabilities or mental impairments prevent them from meeting these requirements. So to access this exception, applicants have to submit a Form N-648, which has to be completed and certified by a licensed medical professional. That includes medical doctors, doctors of osteopathy, and clinical psychologists. The form has to explain the nature of the applicant's condition. It has to establish that it has lasted or is expected to last at least 12 months, and clarify how the condition prevents the individual from learning or demonstrating English and civics knowledge. Now, over the years, this process has been, unfortunately, exploited. There have been numerous cases of fraud, that is, doctors and psychologists who were indicted for submitting false certifications. And when that happens, it doesn't just affect that one applicant, it damages the credibility of the entire system. USCIS takes this very seriously. And so with the June 13th policy update, they've restructured the N-648 process to tighten controls and to increase scrutiny. One of the biggest changes is that the N-648 now has to be submitted at the same time as the N-400, which is the application for naturalization. And this is in itself like a return to the pre-2022 policy. USCIS will no longer routinely accept N-648 forms that are submitted after the N-400. That is, usually they bring it with them to their interview. They won't accept them unless the applicant can demonstrate extenuating circumstances. So, for example, if the applicant develops a disability after submitting their N-400, or if an existing condition worsens significantly, then they can present supporting evidence and request that their late submission be accepted. And that explanation can be submitted in writing or offered verbally during the interview. So say, for example, a person suffered a stroke or an injury that resulted in a TBI. Those would be good examples. So they really are extenuating circumstances. Now, of course, if the reasoning is vague or unsupported, officers have the discretion to reject the form, and most likely they will. And it's important to note that updated forms submitted in response to a USCIS request won't be considered late, but submitting a new or updated N-648 at the interview or any time after the initial submission will be scrutinized as a possible multiple submission. So what does that mean? Well, Ideally, an applicant should submit just one N-648 with their N-400. If they submit multiple forms, especially ones with different diagnoses, dates, or from different providers, because sometimes people think that more is better, officers are instructed to examine those discrepancies very closely. Inconsistent medical conclusions about the nature or origin of the disability or its impact on the applicant's ability to meet the naturalization requirements can put the validity of the certification into question. If two versions conflict significantly, then the officer may find the N-648 insufficient, but only after giving the applicant a chance to explain. So, for example, if the applicant was asked to submit a second form because the first one had issues, and that second form clearly resolves these concerns, then it may still be accepted. But if there are unexplained contradictions, the form could be rejected. And that has major implications for the naturalization process. So let me give you a real-world example of how this might play out. Suppose an applicant comes to you with an existing N-648 that was completed by another clinician who diagnosed them with PTSD. But after conducting a thorough evaluation, that is, clinical interview, record review, appropriate measures, you determine that the applicant doesn't meet the full criteria for PTSD, and instead you find that they meet criteria for major depressive disorder, or perhaps for mild neurocognitive disorder. So in that situation, you're not in a position to explain why the previous provider made their diagnosis, but you are responsible for clearly explaining why you reached the different clinical conclusion. USCIS isn't expecting you to discredit the previous provider. They're just expecting you to demonstrate that your diagnosis is grounded in your direct assessment, and that is aligned with diagnostic criteria, and that you can articulate how this condition impairs the applicant's ability to learn English or civics. And I've actually seen this scenario many times. And what matters most is transparency and specificity in your documentation. It's also critical to understand the distinction between requesting a disability exception and requesting an accommodation. An accommodation is a modification in how the applicant completes the interview or the test. So things like extended time, sign language interpreters, an in-person interpreter, or taking the test somewhere else, but the applicant is still expected to meet the civics and English requirements. These are just accommodations. And in these cases, they don't need to submit an N-648. They just need to explain their request for accommodations. The disability exception, in contrast, says that this person cannot meet those requirements at all, even with accommodations, because of a documented and impairing medical or psychiatric condition. And that is what the N-648 is used for. It is possible to request both. So let's say that an applicant is deaf and also cognitively impaired. They might request a sign language interpreter for the interview and then also submit an N-648 due to an additional disability that prevents them from understanding the civics content. That's okay. But each element has to be clearly explained and supported. So I'm going a little bit on a tangent here, right? Giving you a lot more information. But now let's just talk about what we as clinicians are actually responsible for when completing the N-648. So first and foremost, we have to conduct a thorough examination. It can be done via telehealth, but the rules for telehealth, of course, have to comply with your own state laws and your board's laws, meaning you need to be licensed in the state where your client is. The form has to include a detailed clinical diagnosis, the duration of the condition, meaning that it's going to last more than 12 months, that's just a checkbox, and a clear individualized explanation of how that condition impairs the person's ability to learn English or understand civics. And this explanation has to be specific to the applicant. Generic statements won't cut it. Regurgitating the criteria from the DSM won't cut it. Also, the form has to be completed using plain, non-technical language so that USCIS officers who are not trained medical professionals or psychiatric professionals are able to understand. So no jargon. You may include attachments to the form, like an addendum or test results or psychological report, but you alone are responsible for verifying and attesting to the truth and completeness of all the information. Now, what happens if a Form N-648 is submitted but found to be insufficient? USCIS officers are trained to review the form holistically, taking into account the totality of the evidence. They're not supposed to second-guess the medical diagnosis or demand to see records without a specific reason. But if the form is missing some critical elements, like a clear explanation of how the condition impacts their cognitive functioning, or if the information is inconsistent with other parts of the applicant's record, then the form is likely to be rejected. Officers are expected to review the form according to what USCIS calls the preponderance of the evidence standard. That means that they're looking for evidence that it's more likely than not that the applicant qualifies for the exception. And they must base their judgment on the totality of the record, not just the form in isolation, but everything available to them, including interview testimony, the applicant's file, and any other supporting documentation. So when doing this, officers are specifically instructed to ensure that the form is completed, certified, and signed by everyone, that is, the clinician doing the evaluation, the applicant, and an interpreter if an interpreter was used in person, and that the information on it matches up with other parts of the applicant's record. If there are major discrepancies between, for example, between what's on the form and what the applicant says during the interview, that's going to raise concerns. However, and this is important, officers are not supposed to re-diagnose the applicant or override the clinician's professional judgment just because they have doubt. They can't demand to see medical records unless there's already a credible inconsistency they're trying to resolve. They can't require specific testing or procedures. And they can't assume that the form is invalid just because the applicant didn't previously disclose the condition in a different immigration exam. That might raise questions, but it can't be the sole basis for denial. Also, they're not allowed to disqualify a medical professional just because that person shares their applicant's culture, language, nationality, or because they don't like them. The process is supposed to be fair and rooted in evidence, not assumptions. Now, this is what they're instructed to do. We can't guarantee that this is what always happens. If USCIS identifies problems with a form N-648, the applicant is going to have to submit a new one. And in that case, we as clinicians must be especially careful about consistency, making sure that the new form addresses the original issues without introducing new ones. Because at that point, the margin of error gets much smaller. So let's say, for example, the officer finds significant inconsistencies between the N-648 and past medical records, or between the form and what the applicant says during the interview. Maybe the applicant had a green card exam, which is what they need to do in order to adjust their status, and at that point they didn't mention any disability. Or maybe they say something at the interview that directly contradicts the form. In that case, USCIS might issue a request for evidence, an RFE, or even ask the applicant to get a new N-648 from a different provider. I've seen that happen a lot. Here's another example that I've seen come up more than once, especially with refugees. When someone applies for admission to the U.S. as a refugee, they go through an extensive and highly structured vetting process. And that includes a medical evaluation and multiple interviews. So let's say this process took place in 2015. And at that time, the applicant didn't disclose any psychological symptoms or cognitive issues, which is not unusual. People often minimize or don't feel safe disclosing certain things in those settings, especially when trauma or stigma are involved, or sometimes they don't even realize it or they don't have a word for it. So now fast forward, that same person comes to you in 2025 seeking a disability exception. during your clinical interview, they disclose that they've been living with post-traumatic symptoms ever since they witnessed their loved one being killed during the war in Iraq in 2007. Maybe they've never had a chance to speak about it until now, or maybe it's just gotten worse with age or with stress. But if USCIS, at their naturalization interview, asked them where their symptoms stem from, and they honestly answer from the war in 2007, then an officer might flag that. They might say, wait a second, but when you applied as a refugee in 2015, you didn't mention that at all. And that discrepancy alone can cast doubt on the validity of the current Form N-648. It doesn't necessarily mean that the applicant is being dishonest. They're not. But it does mean that we as clinicians need to be aware that these gaps in the historical record exist. So where appropriate, we should be proactive in explaining how, perhaps, trauma can go unreported for years, or why someone might not have disclosed sensitive information during a high-stakes immigration process a decade ago. Because if we don't help make sense of those inconsistencies, they can work against our client. Another issue that's been raised in these new policies is the use of interpreters. So if an interpreter was used during the clinical evaluation, they must sign the interpreter section of the N-648, unless, of course, the exam was conducted via telehealth, in which case, then the mental health professional signs on their behalf. But here's a twist. If that same interpreter also shows up at the naturalization interview, and the officer needs to question them about anything in the evaluation, like what was said or what they look like or anything about the evaluation that took place in your office, the interpreter can be disqualified from continuing as the applicant's interpreter. And that is not uncommon, especially when clients trust a particular interpreter and want consistency. They typically show up with the same interpreter. So if the USCIS officer needs to ask the interpreter any questions about what happened during the clinical evaluation, such as how the applicant communicated, what was said, or whether anything was clarified during the exam, then the interpreter essentially becomes a witness. And as a result, they can no longer serve as the applicant's interpreter for the rest of that interview. Why? Well, because now there's a potential conflict of interest. USCIS policy requires that if an interpreter is going to be questioned as a witness, they can't simultaneously be responsible for interpreting the rest of the interview. So unless there's a valid exception granted for good cause, like I'm assuming if a person speaks a dialect that there's no other professional interpreters available that speak that same dialect, for example, then the interpreter, unless that happens, then the interpreter might be disqualified and the interview may need to be rescheduled so the applicant can bring someone else, or that USCIS can provide another language service if available. If you're looking to add a high-impact, high-income service to your practice, I've got something for you. Head to the link in the description box to check out my expert training in immigration evaluations, a comprehensive program designed to help you confidently conduct immigration evaluations, connect with attorneys, and build a sustainable practice. Now let's get back to the show. Now let's talk about what USCIS considers to be credible reasons to doubt the validity of the N-648. These include signs that perhaps no exam actually took place, that there wasn't an evaluation, or that the form was filled out by someone other than the authorized professional who certified it, or that the applicant paid for a form without ever being evaluated. And yes, this unfortunately happens. It also includes fraud or misconduct by the professional, in our case, mental health professional or the medical professional, such as, if they're under investigation for immigration fraud or being disciplined by a licensing board, which is also unfortunately common, or not common perhaps, but it has happened. Other red flags include discrepancies with past applications, conflicting interview responses, or known involvement in fraud by interpreters. So if any of these concerns are present, USCIS may find the form insufficient and refer the case, in these extreme cases, to their fraud detection and national security unit, and that is a serious consequence. Now let's shift gears for a moment and talk about what happens at the interview stage. If the applicant's N-648 is accepted and they're exempt from the English and civics testing, then great, they can proceed. Best case scenario. If it's found insufficient, they give them a chance to take those tests. And if they pass the tests, then the interview continues. But if they fail, then they'll be given a second chance, which is usually 60 to 90 days later. If the N-648 is still found insufficient at that re-exam, and the applicant can't meet the test requirements, then the application will be denied. The officer will explain why, usually in writing, and the applicant won't be given another opportunity to submit a new form or take the test a third time. The only option at that point is either to start over or to request a hearing or an appeal. So the applicant can file another form within 30 days of the denial, and at that hearing, they can submit additional documentation, including a new or initial N-648, but only one. And remembering that if they've already submitted an N-648, that N-648 is on file. It's in their file. So it's very, very important for us to read it, especially if that contributed to the denial. So in these cases, they get one more chance to prove their eligibility and one more chance to pass the English or civics requirement if they're not exempted. So where does that leave us, the mental health professionals? Well, this policy update places a greater burden on us than ever before because we need to make sure that we're not only thorough in our evaluations, but also crystal clear in our documentation. We need to take responsibility for the accuracy and clarity of everything that we submit. And we need to stay alert for any signs of fraud or misuse of our credentials. Submitting a weak or vague N-648 is not just a missed opportunity for the applicant, it could put your license and reputation at risk. So please, take your time with these evaluations. Review the policy manual if you can. Make sure that every box is checked, every diagnosis is supported, and every explanation is clear, individualized, and clinically sound. So let's quickly recap the key takeaways from this episode. As of June 13th, 2025, Form N-648 must be submitted together with the N-400, that is the application for naturalization, unless there are clearly documented extenuating circumstances. Submitting multiple forms or submitting one late raises credibility concerns that could delay or altogether derail the application. Second, the form has to be thorough, specific, and clearly demonstrate the connection between the applicant's condition and their inability to meet the English or civics requirements, even with accommodations. Third, USCIS officers are reviewing these forms more critically than ever, but they're also bound by policy to avoid overreaching into clinical judgment or relying on cultural bias. And then finally, as clinicians, we have an ethical and legal responsibility to be precise, to be honest, and well-informed when completing these evaluations. A well-prepared N-648 can make all the difference for someone's path to citizenship, and a poorly done one can carry serious consequences. Now, I know that might sound like a lot, and yes, the bar has been raised, but I want to say this clearly, that don't let these new guidelines scare you away from doing this work. Immigration evaluations, especially disability exception evaluations, can be very meaningful and impactful assessments that we do. They give us a chance to advocate for people who have already been through sometimes extraordinary hardship. So when done thoughtfully and ethically, these evaluations can open doors to citizenship, to stability, and to healing. The guidelines may have gotten stricter, but they're also clearer. And that clarity can actually help you. Because if you follow the framework, if you take the time to be thorough and document your findings with integrity, then your work will stand up to scrutiny. So yes, the expectations are higher, but so is the potential for impact. And if you're not sure where to start, or if you want more guidance, then I've got tools to help you. I offer an on-demand training specifically focused on Form N-648, where I walk you through the entire process. It includes practical tips, examples, sample forms, and all the strategies that I've developed over the years of doing this work. So whether you're new to immigration evaluations or you want to refine your approach, this course will give you exactly what you need to do this work well and ethically. You can find it at psychevalcoach.com. Just look for the N648 course and you can start learning today on your own schedule. And I'll also make sure that there's a link to it in the description box. So thanks again for tuning in to this special episode. Take good care, and I'll see you next time. I appreciate you spending time with me today. If you enjoyed this episode, share it with a fellow mental health provider who needs to hear it. And if you haven't already, hit subscribe so you don't miss my next one. See you then.